The next case on the argument calendar is difficult for me to pronounce. I'm not sure, Tekle, and you can help me when you get up here, counsel, versus Sessions. Hang on just a sec till we get set up. Okay, when you're ready.
Yes, good morning, Your Honor, and before I proceed, it is my intention to reserve the balance of my time for rebuttal. In terms of assisting the court with pronouncing my client's name, it's Abraham Gebrgizaber Tekle.
Okay.
Okay, thank you.
Thank you.
Commencing on page 14, line 2 of the government's brief, the DHS focuses on my client, Abraham Tekle's initial false testimony regarding his prior travel to Japan. Because Mr. Tekle's integrity is important, this false impression needs to be rectified. Like his namesake, the patriarch Abraham, my client, modern-day Abraham, told a lie in order to save his life. The Abraham of old told the Philistine king of Gerar.
He admitted to lying, right? He testified that he had in fact been traveling. He first said he hadn't traveled to Japan, and then he changed his testimony and said, yes, he had been in Japan. And the reason he gave was he didn't want to be sent back to Japan. Is that all correct?
Correct, Your Honor.
Okay.
Thank
And you're saying he had good reasons to lie to the immigration officer, but the immigration officer didn't have to credit them if there was an admitted lie to the officer.
If I may, thank you. I'll explain. The Abraham of old told the Philistine king of Gerar that his wife Sarah was actually his sister. Both the Abraham of old and my client, modern-day Abraham, were in a foreign land and in fear for their respective lives. The Abraham of old misjudged the king, who would not have killed Abraham, in order to take Sarah as the king's wife. We know this because the king did not harm Abraham upon learning the truth, nor did he harm Abraham because he had not been truthful. While the king was displeased that the lie would have led him to make a serious mistake about Sarah, the king understood that to save a life was tantamount to saving the whole world. The king knew that a dead patriarch is of no use to his old family. So why did my client, modern-day Abraham, lie about Japan? He mistakenly thought that if he told the immigration judge about Japan, she would deport him there, and in turn, the Japanese government would ultimately deport him to his homeland, Ethiopia, where he would then be murdered. And I cite to the administrative record at page 904, lines 24 to 25.
Was the Japanese business the only false evidence submitted by Mr. Abraham? Abraham?
Correct, Your Honor. I had planned on delving into that in rebuttal. So hence, we would respectfully submit that a lie to save a life is not a moral evil. And on that,
IJ found other inconsistencies, correct?
Excuse me?
The IJ identified other inconsistencies.
According to the IJ, which I intend to speak to on rebuttal.
Among other things, the IJ credited the testimony of the government witness that the warrant was fraudulent.
And again, on rebuttal, I plan on...
No, you'd better say it right now.
I'll say it right now. Okay, specifically as to the warrant that I believe appears at AR 2141. Initially, I believe that the forensic expert should not have been allowed to testify, and the reasons for that are set forth ad nauseum in my brief. And moreover, her testimony was not persuasive. There was a lack of exemplars, no alternative method identified, vague references to documents on file. Which city administrator was she talking about? Most importantly, there was no foundation that only laser jet printers were used and that no jet printers were used contemporaneously. In the U.S. here, we're familiar with the courts changing forms all the time from year to year. This does not mean that the prior form is no longer genuine. And on the other hand, I'd like to balance what I just said against Abraham's wife, Ascale's detailed testimony as to her having been served with the warrant on December 7th, 2005, and Abraham's detailed testimony regarding his promptly fleeing from Ethiopia later that same day.
Right, but all that's hinged upon whether or not it's a valid warrant. I mean, if there was no such warrant, both of them are lying.
Well, we maintain it was a valid warrant and that their conduct...
I understand that, but unless we're prepared to say that there was improper fact-finding with respect to the warrant, we have to live with the finding that there was the warrant didn't exist.
Okay. Yeah. Thanks. And so I'd like to reserve the balance.
Okay, why don't we hear from the government, and then you've got a little over 4 minutes. Yeah.
Thank you. Thank you. If I may, some preliminary housekeeping issues. On the issue of my client's location in July 2005, all one has to do is look at the government's exhibits 11 through 14 to see that when the wife applied for a visitor visa to the U.S. in 2002, she set forth that the location of her husband was in Japan. She was denied in 2003, 4, and 5, and you look at the 2005 application, and there's no indication of that whatsoever, so I'm going to humbly submit that that's either a error, clerical error on the part of DHS, or simply a red herring. The wife did not participate in any mistestimony.
Well, except for, and we've talked about this before, depending on how one characterizes the warrant.
Again, and I stand on my prior arguments on that. On the passport issue of Abraham, he had renewed it in 1998, 2-year renewal. At the time, there was my clients are ethnic Eritreans living in Ethiopia. A war was going on, and there was no renewal after its expiration in September of 2000. And we submitted that passport, the original, and a copy is at tab T of our exhibits. Thereafter, he did leave Ethiopia for Kenya by ground transportation, and by his testimony in Kenya, somebody had doctored his expired passport so that he could then travel to Japan. So there was no inconsistency there. In terms of the REAL ID Act, I agree that assessing credibility is important, but it's also important not to lose sight of the fact that that rose out of the horrific events of 9/11, and its main purpose is to protect us from allowing terrorists into our country, and nobody here in good conscience would submit that my clients are terrorists. Now, on the important issue of my client Ascale and the children's independent application for asylum, initially based on ethnicity and imputed political opinion as well. Well before she met her husband, my client was in jail in the mid-'80s. Because of political opinion. But moreover, the court properly recognized, based on medical evidence, that my client was at a young age subjected to the horrific practice of female genital mutilation. Under the Mohammed versus Gonzalez case in the matter of Kasinga, this is a permanent condition. The judge did not hide her reasoning whatsoever as to only grant Ascale the higher standard of proof that withholding requires, and not the lower standard asylum to which she was entitled. One just has to take a look at page 20 of her order, dated July 13, and see that the court's animus, right or wrong, was directed toward the husband. But we respectfully submit that it's not correct for the judge to deny the wife her asylum, where she endured such extreme persecution solely to punish the husband and therefore break up the family. On the issue of the children, they're here under DACA, and as we all know, that's a tenuous position from administration to administration. And so the judge thought wrong, I believe, that they were somehow safe and secure here. And again, we may be putting the cart before the horse. The judge assumes that if you grant the wife asylum, she's going to file the derivative petitions for the husband and the children. She may, but at that point, the service is not precluded from then examining that and whether or not the service wants to grant that based on what happened in court, if the service continues to believe that. Thank you, Your Honor.
Okay, thank you very much. Thank both sides for their arguments. I'll just use the second part of the name. Tekla versus Sessions is now submitted for decision. Thank both sides.